The U.S. Supreme Court heard oral arguments today about whether the sedative used in Oklahoma's lethal injections works well enough to prevent inmates from feeling an unconstitutional level of pain during executions. The case stems mostly from the so-called botched execution of Clayton Lockett a year ago, when the state first used the drug midazolam rather than the barbiturates it had previously used. The sedative is used so the inmate doesn't feel the effects of the next two drugs, one that paralyzes the body and one that stops the heart. The court is expected to rule by July on whether the sedative meets the constitutional protection against cruel and unusual punishment. Our man in Washington, Chris Castell, joins us now on the phone. Chris, it's a busy time in Washington. Thank you for your time today.
Absolutely, Dave. Glad to do it.
And this isn't the case just about the death penalty itself, though, is it?
It is absolutely not, Dave. This is a pretty narrow case, really, and it's about, as you said, does this sedative work? Does it, render the inmate unconscious so he doesn't feel the pain of the next two? I mean, I think there was a lot of kind of speculation, over broadening of this case when the court first agreed to accept it in January, that this is a challenge to the death penalty. But what people have to remember going into this is, number one, the Supreme Court has upheld the constitutionality of the death penalty. You're not going to revisit that. How the court is about its precedents. It has already said the death penalty is an acceptable form of punishment under the Eighth Amendment. It has also specifically upheld a three-drug protocol for lethal injection. That was a Kentucky case a few years ago, and that was with the use of barbiturates as a sedative that renders the inmate into a very deep unconsciousness, so he doesn't feel what the drugs that then follow. What's happened since then in a lot of states, and Oklahoma has faced this, is that a lot of drug makers do not want to provide that sedative to states for execution. Basically what they're saying is, we're not going to give you a drug to kill people. So the states have been increasingly kind of scrambling for that first drug, that sedative drug. The first drug is a sedative. The second drug is it paralyzes an inmate so he can't move. And then the third one stops the heart. And some states have still been able to get doses of the barbiturates that have been used previously, and specifically upheld by the Supreme Court. In fact, I think the lawyer for the inmate said today that 11 states still use those barbiturates. So this is a case of whether this drug that Oklahoma was able to get as an alternative, it's also been used in Florida, does serve the purpose of sedating the inmate enough to where he won't feel pain.
Chris, we mentioned there may be a ruling by July, or there's expected to be a ruling by July, but today, was there a clear division among the justices?
There's a very clear division among the justices, Dave. The conservative bloc of justices, and that's basically 5 of them, the majority of the 9, some of them seem peeved that they're even hearing this case. And here's why. There's a lot of this dispute in this case, all the way here in the Supreme Court, is whether this drug, midazolam, has the effect that it's supposed to have. Well, that's not the Supreme Court's job. They don't get into factual disputes about whether a drug is works this way or doesn't work that way, or like you solve all that stuff in Oklahoma City. Then you go to the Court of Appeals in Denver, the Circuit Court. Then you come up to the Supreme Court with a legal argument, not a factual argument. All those facts are decided down at the lower levels. You come up to the Supreme Court with a constitutional argument, not a pharmacology argument. And that's what some of the, you never know who exactly agreed to even hear this case, but my guess would be that the 5 conservatives did not even want this case before them. They don't want to argue about whether a sedative works on your central nervous system or your brain. That's not what they're here to do. So, but the liberal justices are really concerned about whether this sedative works or not, and whether, if it doesn't work, these inmates who, that it's being used on are actually feeling great pain and a violation of their Eighth Amendment protection against cruel and unusual punishment. So I think it's always really risky to guess about the court, but I think you've got a 5-4 division here, with 5 leaning very strongly, or at least somewhat, towards Oklahoma's position in this case, which is that they can use this drug.
Chatting with Chris Castile. He's joining us from Washington today. And Chris, let's back up and look at the big picture here. What impact could this case have on lethal injections?
You know, I think ultimately and it depends on whether as I just said, some justices think this case shouldn't even be before them, and they can actually rule that way. You know, we're not even going to get into this whole thing about midazolam. That's a fact-finding thing. Or they could come out with a new ruling about what the threshold is for, you know, how a sedative is supposed to work so the person doesn't feel pain. They could do that. There could be a new kind of standard issued in regard that will influence lethal injections in the future. But I think, you know, what the court spent a lot of time on today, or at least, you know, a good amount of time on, is the whole issue of, you know, that I mentioned earlier about how the manufacturers of these drugs had made it very hard for the states to obtain them. And what the conservative justices told this attorney for the inmates is, look, it's death penalty abolitionists, you know, kind of like yourself, that there is a reason that these states can't get drugs that we know work. So, you know, the upshot of that is eventually states won't even be able to get a hold of this one that's under dispute now, midazolam. Already, as you know, a couple of weeks ago, Oklahoma legislature passed execution method by gas chamber as an alternative. Utah, I think, has moved toward going back to the firing squad. So what you're going to have is, you know, this kind of constant debate about alternatives to lethal injection, which, by the way, as you may know, was actually devised in Oklahoma in the 70s as the most humane method. But I think what's going to happen is states are going to move to other things. They don't have to constantly, you know, mess with this, and the court's going to be kind of constantly having to rule on whether firing squad, gas chamber, whatever, might meet the protections of the Eighth Amendment's guarantee against cruel and unusual punishment. So the death penalty debate method of execution will continue in the foreseeable future. Scott Pruitt, and I know I'm rambling, but Oklahoma Attorney General Scott Pruitt's suggestion, when I talked to him about all this last week, was that states should get together and have their own compounding pharmacies, basically. You know, they don't have to buy the drug from somebody else and make it. You know, they'll get the chemicals to make these barbiturates, and then they don't have to worry about suppliers anymore. I assume they would still have to get willing pharmacists to do this, but it would at least, you know, reduce the supply chain problem.
An interesting solution to that potential roadblock. You call it rambling, we call it good analysis of all the nuances of this case. Chris, thanks for your time today. We appreciate it.
All right, Dave, glad to do it. Sorry I went on so long.
No worries at all. The High Court is certainly busy this week. Chris Castile is all over it. You can find his coverage in the Oklahoman and online at newsok.com.